The eviction process in Arkansas is relatively straightforward. The most common method of evicting a tenant is through an unlawful detainer action, and that is the action that I will cover here today. Evicting a tenant in Arkansas is a two-step process. The first step is a preliminary determination of the right of possession. This is the phase of the wrongful detainer action that most people think of when they think about evictions. This phase is about removing the tenant from the property, assuming the landlord has a right to do so. The second phase is about determining damages, that is, how much money, if any, is owed. Backed rent is the most commonly understood aspect of these type of damages, and may be awarded by the court at this phase of the action. First, to evict a tenant, a landlord must have a valid reason to evict. Some valid reasons include violation of lease terms, including a failure to pay rent, having pets if the lease prohibits it, or if the tenant is housing more occupants on the premises than the lease permits. Another valid reason is if the lease term expires and the tenant refuses to leave, despite the landlord's demand that he or she do so. There are, however, invalid reasons to evict, such as a simple dislike for the tenant or the landlord's desire to put a different tenant into the premises. These reasons are only invalid, however, if the tenant has remaining term. A landlord may replace or remove a tenant at his or her discretion for almost any reason once the lease term has expired. A major exception being that a landlord cannot remove a tenant on an unlawfully discriminatory basis, such as on account of the tenant's race or gender. If a tenant refuses to pay rent or otherwise adhere to the terms of the lease agreement, and the landlord needs to begin the eviction process, the first step is to provide the tenant with a written notice demanding that the tenant move off the premises within 3 days. If the tenant fails to comply, the landlord may then file a complaint against the tenant with the court. There is generally a fee associated with this, which varies by county. The complaint must also be served on the tenant. This will generally require the utilization of a process server. After the tenant has been served, he or she has 5 days to file a response with the court. If the tenant fails to respond, the court will issue a writ of possession, which entitles the landlord to possession of the property. If the tenant does respond and pays any rent due to the court, a hearing date will be set for both the landlord and the tenant to make their respective arguments before a judge. It is important to note that just filing an answer is not enough for the tenant to remain on the property while the hearing is pending. The tenant must also deposit enough money with the court to cover any backed rent and continue to pay rent due into the court registry during the pendency of the proceedings. If after the hearing the court rules in the landlord's favor, the writ of possession will be issued at that time. If the court rules for the tenant, however, it will not issue a writ of possession. This will generally happen where there is a dispute as to whether or not the tenant actually breached the lease agreement, and so usually involves matters other than failure to pay rent. Once the writ of possession is issued, the sheriff will serve the tenant with the writ. At that point, the tenant will generally have 24 hours to vacate the premises. If the tenant still refuses to leave, the sheriff will forcibly remove the tenant. The second phase of the proceedings is the damages phase. Once a landlord's right to possession of the premises is established, proceeding to this phase may not be necessary. As the saying goes, you can't squeeze blood out of a turnip. A tenant that had the money to pay rent probably would have, so any judgment the landlord obtains may be unenforceable on account of the tenant's insolvency. And so the landlord is left with additional legal fees and nothing to show for it. Individual circumstances vary, however, and there are times when rent is not the main issue, such as if a tenant causes a large amount of damage on the property. So there are circumstances where pursuing the matter through the end could be of benefit to the landlord. Landlords should remember, however, that tenants have the right to dispute the landlord's claims, and may be more likely to do so if the landlord demands more than the tenant simply leaving. The tenant can make counterclaims against the landlord and seek his or her own damages. All of these matters should be considered in conjunction with the landlord's attorney based on his or her specific circumstances. I hope that this has been helpful. I have included my firm's information here, so please feel free to reach out to me if you have any questions. Thank you.